Please be seated. We'll hear argument in 2932, Transcor Astra Group against Petrobras America. I should have announced earlier that Justice Lehrman and Justice Devine cannot be present this morning, but they do both expect to participate in the decision of the case.
May it please the court, Mr. Novak will present argument for the petitioner. The petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court. We have both an appeal by Astra, my client, and a cross appeal by Petrobras. I intend to deal with our appellate issues first, and then Petrobras's issues, if the court would allow me to. There are some basic facts that are common to both that I think it's important that the court focus on. We have handed up bench exhibits, and our last exhibit describes the parties' changing relationship. And it's brief, but I would like to just give you an overview. In September 2006, the parties became co-shareholders and partners in a joint venture owning a Texas refinery. They also had a trading partnership. That relationship lasted until April 27th, 2009. At that time, Astra transferred all of its ownership interests pursuant to an arbitration award in the exercise of a put to Petrobras. It was no longer a co-owner. It was no longer a partner. From April 2007, April 2009, until July 29, 2012, June 29, 2012, the parties were in litigation. They were littering the landscape with cases. There are, I think, 11 different lawsuits. We had collected, Astra had obtained judgments for $750 million. We had additional claims for over $300 million. Petrobras was facing a financial exposure of $1.1 billion. And the parties during the period of December 2011 through June 29, 2012, negotiated the settlement agreement that is the subject of this appeal. At the time of the negotiations, they were no longer shareholders or partners. There were no other business dealings between the parties. There were 13 different disputes and litigations that were being settled, and there was $1.1 billion in claims. The parties were represented by...
Did Petrobras raise as a claim or a defense in any of those disputes breach of fiduciary duty or unlawful activity, either by the venture itself or by Astra?
No, Your Honor.
Okay.
It's undisputed that the settlement negotiations, which lasted quite some time, began with the draft of a settlement agreement prepared by counsel for Petrobras, which was sent to counsel for Astra. That first draft of the settlement agreement included a general release, and in fact, the settlement agreement was entitled Settlement Agreement and Mutual General Release. Both sides got full general releases. Secondly, the settlement agreement had a disclaimer of reliance prepared by Petrobras' counsel. This was a mutual disclaimer of reliance. Third, there was an exclusive forum selection clause. The forum selection clause, again, drafted by Petrobras' counsel, and might add, these provisions were never changed. The disclaimer or the forum selection clause were never changed in negotiations, provided that only the Texas courts would have jurisdiction for any dispute arising out of or relating to the settlement agreement. So those provisions stayed unchanged. The closing occurred in June 2012, and since the closing, several years later, there was a great scandal in Brazil. There was corruption discovered with regard to Petrobras. This led Petrobras to claim that in this particular instance, a 2006 stock purchase agreement from which the parties' relationship emanated originally, but which closed in 2006 when they became partners, that was procured by fraud. Supposedly
not
that
just
fraud,
by fraud, but by criminal bribery. Right?
Yes, Your Honor, but the civil claim on which they are relying to invalidate the settlement agreement for non-disclosure was fraud.
But understanding that what is alleged to have happened here is that officials of your client are alleged to have bribed officials of their client, how can we consider this to be an arm's length transaction?
Because there are two separate transactions. One was in 2006, one was 2012.
And there are allegations of bribery with respect to both, I believe.
No, Your Honor. There is an allegation that sometime during the period 2011 to 12, there was supposedly an inquiry made by someone of Astra to someone at Petrobras, who then passed it on to someone else at Petrobras, asking whether or not if there were an $80 or $100 million, it was unclear what it was, whether it was a reduction in the demand or whether it was going to be, we're going to give somebody money. There was an allegation of an offer. There was no allegation, and there was ample discovery in the state court. Judge Gamble gave them 12 depositions. They got thousands and thousands of pages of documents. There has never been an allegation of any illegality, any corruption, any bribery that occurred that in any way influenced this settlement agreement. It is a totally non-illegal. There is nothing called for that's to be performed that's illegal. It wasn't procured by illegality. It was totally, what I would say, legitimate, meaning not involving any illegality.
And to be clear, no allegation of any such conduct at all, period, whether it influenced anything or not. But you're saying there was no allegation ever made of any such conduct before 2011?
With respect to, the allegation is unclear because the collaboration statement on which it's based was a translation of a Brazilian interview, and it simply seemed to be there was some inquiry made of one person who then asked another person whether or not it would make any difference, and the inquirer was told, we're not involved in the settlement negotiations, we have nothing to do with it. Nothing ever happened. In the collaboration statements which are being relied on for this, there is no follow-up. The Brazilian prosecutors and interviewers asked no further questions. They didn't ask anybody else that was interviewed. So we think it was just a translation glitch, and it really was, well, if we reduced our $1.1 billion demand by $80 or $100 million, do you think you'd settle then? We don't know. We have never had the opportunity to question anybody about what is behind the double or triple hearsay in this collaboration statement. So if I may, if I have answered your question. So going to the first issue about the release, this is a customary carve-out, which we understood, which customarily is put in to make sure that someone has a right to enforce any obligations which arise under the settlement agreement. The argument was made that this had to be construed narrowly. The Court of Appeals thought because it was a general release it did. We think that it's now conceded that it did not have to be construed narrowly because the narrow construction rule only applies. Did you identify who was covered by the release, and was the claim covered? Those are not in dispute here. The issue is whether or not the carve-out transformed this, what was proclaimed to be a general release of the broadest possible type. That's what it says in the release. Whether that was changed into a limited release in accordance with the parties' intentions. The Court of Appeals, because it focused on narrow construction, while reciting the rules of traditional contract interpretation, never applied them to the interpretation it reached.
Whether it's broad or it's narrow, why doesn't a claim seeking to rescind the 2012 settlement or to undo payments made under it based on breach of fiduciary duty relate to be connected in some way with the interpretation or enforceability of that agreement?
I'm happy to answer that question, Your Honor. The words that are critical here are the limiting words, breach, enforcement, or interpretation. The Court of Appeals read it as though it read, the carve-out covers anything associated with the settlement agreement. And because it said the fiduciary duty occurred during the period of the settlement discussions, it was within the carve-out. It completely read out the words, breach, enforcement, interpretation. The correct way to look at this is, number one, the release provides in the carve-out that it is a subset of claims by Petrobras. The release claims are defined as the Petrobras claims. The
But
carve-out
if
then...
you're seeking to rescind the agreement or to undo payments made under it, it seems like that relates to the enforceability of the agreement.
The carve-out does not deal, well, there are several things that you have packed into that question. First, the claim for fraud was the only claim that sought to undo the settlement agreement. The breach of fiduciary duty was not a basis for undoing the settlement agreement. It is the fraud claim...
They didn't seek rescission for breach
Not
of
based on
fiduciary
fiduciary duty,
Okay,
no.
what about disgorgement of payments made under the agreement?
I don't believe they did, because the individuals who breached the fiduciary duty were not parties to the settlement agreement as such. And there is no claim that a breach of fiduciary duty gives them a right to invalidate the settlement agreement in any way. The only claim for disgorgement or to invalidate was based on fraud. Excuse me. So if you look at the carve-out, it is a subset of the claims by Petrobras that have been released. So first, you must have a claim by Petrobras. Second, the question is it a claim by Petrobras that seeks to enforce a right arising out of the settlement agreement, either for its breach or to enforce it, or for interpretation of your rights under the settlement agreement?
So if the Court of Appeals says the Petrobras plaintiffs also allege claims for breach of fiduciary duty, aiding and abetting and conspiracy, and sought to limit or undo payments made pursuant to that agreement, that's not correct.
I don't believe it's correct, Your Honor. I don't think fiduciary duty is a basis for getting any relief under the settlement agreement. You would have to invalidate it in some way, or you're suing a party for some relief under the settlement agreement. You can't sue some third party to get relief under the settlement agreement from the other parties.
So it's your view that theoretically, at least, they could prevail and recover on their breach of fiduciary duty claims, and all the rights and obligations under the settlement agreement would remain intact?
Yes, Your Honor. Those are two separate things. And I might, if I could finish my explanation of the carve-out. The point is, if you read breach enforcement interpretation, that would cover situations where you have some right under the settlement agreement. If you don't read those in, if you eliminate them, then you can say, well, it covers everything that might apply, irrespective of whether or not Petrobras is suing to achieve a breach, a remedy for a breach. Under the interpretation that was proposed by the Court of Appeals, it really wipes out the release, because there's no limiting principle. If you take away the requirement that it be a claim by Petrobras to enforce its rights, either for breach enforcement or interpretation of its rights, then everything relates to the settlement agreement, because the settlement agreement deals with all of the parties' past dealings and a release of all of the parties' past dealings. So by definition, if the carve-out relates to anything to do with the settlement agreement, every time we invoke the release, it'll be a nullity. That could not have been the interpretation.
Just to make sure, the release was a mutual release.
It was mutual release to protect.
And so Astra released any and all claims that it had or could have had or might have had as well.
Exactly.
And so wouldn't the carve-out have also permitted Astra to assert claims for breach enforcement or interpretation
Of the settlement agreement.
So when you say it had to be a claim by Petrobras,
Only
that's not really true.
Well, it's
could have been a
both
claim.
literally true under the Petrobras release, but it's not true with regard to the Astra release. That's right, both sides.
All right.
I was only referring to the actual carve-out. So they completely wiped that out, and the net effect was to take what everyone said was the broadest type of general release and to convert it into a limited release. And that is absolutely contrary to what the parties intended to do, which was to clean the slate once and for all. Your Honors, I see I only have about a minute and a half. I wonder if there's any issue in particular that perhaps Justice Busby or others have that I can answer, rather than me talking about things that are not particularly concerning to anyone.
Well, do you agree that the fraud claims go to enforcement?
No, Your Honor. The claim by Petrobras to invalidate the release is not a claim by Petrobras that comes within the carve-out. Absolutely not. Because the claim by Petrobras to invalidate the release means it's not there, so you can't rely on it. It's like chicken and egg. So that's the only claim that doesn't come within the release. It wasn't specific enough to be a release of a fraudulent inducement claim within a release itself. We relied on a disclaimer, and only the disclaimer. There was no fraud because there was no reliance, because we were told by Petrobras they were relying on their own judgment, and they were not relying on anything, any statement or representation anyone else said. I would like to discuss briefly this individual benefit argument. This release language that releases all the officers, agents, employees is customarily used in innumerable settlement agreements. And Petrobras's position is that language was, they agree it was intended to benefit the individuals. Their argument is it was only intended to benefit the individuals in their corporate capacity. But now Petrobras has conceded in its respondent's brief, there is no such thing as liability for a tort on behalf of a corporation in your corporate capacity. There is no such thing. An agent commits a tort, he's not immunized because he is acting as an agent for a corporate employer. He is personally liable. That is the only liability that Petrobras employees faced. It's the only liability that Astra's employees faced. That is the only liability for which they needed protection. If you did not protect the officers and directors and employees of a corporation that settles claims against it, what happens is they could be sued, they bring claims over, and the corporation is dragged right back into the litigation that it thought it settled. There is no case that has ever said that this language is not effective to preclude claims against the named individuals. And there's no issue here whether or not any of them are identified. We know they're identified. There is no protection that was required. There would be no purpose to adding them to the release.
Any other questions? Thank you, Mr. Novak. We'll hear from the respondents.
May it please the court, Mr. Colts will present argument for the respondent.
Thank you, Your Honor. Bill Katz here on behalf of the respondents and cross petitioners that I'll refer to as Petrobras. Before addressing some of the court's questions to Mr. Novak, I'd like to start with a couple of issues with respect to factual background here. This case, in our opinion, is about the enforcement of contracts as they are written, as well as ensuring that Texas courts do not interfere with pending arbitrations. Our claims arise from one of the largest bribery and corruption scandals ever, and for purposes of the defendant's motions for summary judgment, the defendants acknowledged that the courts, including this court, must take as true the fact that bribery occurred, that the defendants knew about it, and that the defendants breached their fiduciary duties.
So it's not
Release?
just, go ahead.
Did the release cover any claims arising out of any activities alleged to violate the laws of the United States or any foreign state? And if it did, why wouldn't those claims have been settled?
Because those claims aren't settled because of the carve-out. So the purpose of the settlement agreement and the way that the release works, and I think we provided the court with some exhibits. If you look behind tab A, we mentioned section 3.01 of the settlement agreement. This is part of the recitals, and it makes it clear that the parties are going to be settling certain claims except as otherwise provided in the settlement agreement. I think it's important to keep in mind the parties' relationship was going to be continuing after the settlement agreement. That's behind tab tab C, where the parties were still going to have to interact with one another. And so the way the settlement is...
Except that the joint venture interest, the 50% interest, had already been transferred to Petrobras before the negotiation of the settlement, right?
Well, I'd say two things on that. The joint venture interest had been transferred, but that doesn't affect the existence of fiduciary duties. In response to Justice Busby's question, the settlement agreement is not an arm's length transaction for a couple of reasons. First off, because there are allegations of a bribe being offered in connection with it, and much of what my friend Mr. Novak said is fact dispute. He acknowledged that it's unclear as to what that means. So first off, to the extent that there's some disagreement about what that means and whether or not it affected the agreement, that's a fact issue that would require reversal. I think the second point that Mr. Novak omitted, obviously, is even if the ownership interests were transferred in 2009, that
Well, if they were, right? You say even if they were, like they weren't.
well, even if they were.
They were, correct?
Let's assume that they are transferred. They're transferred. They're transferred. It doesn't matter whether or it doesn't impact or prevent the existence of fiduciary duties. Why do we know that? We know that based upon the internal affairs doctrine, which is the statutory choice of law provision, which basically says that fiduciary duties of companies are dictated by the place of organization. We know that PRSI was a Connecticut corporation. We know that PRSI Trading was a Delaware partnership. We know that under Connecticut law and Delaware law, this is the Pacelli case from Connecticut, as well as the Belcom case that we cite in our papers from Delaware, that fiduciary duties continue even if the parties are in ongoing disputes. And that, in fact, that's consistent with Texas law. This court in Schlumberger cited favorably the Johnson versus Peckham case from 1938, which makes it clear that even if partners are in a dispute, fiduciary duties continue. And also, keep in mind, the transfer of the ownership is different than whether or not certain individuals owe fiduciary duties. The law on fiduciary duties, if you want to stop being a fiduciary, you would have to affirmatively repudiate your duties. And even then, there's no evidence in the record of that. So Mr. Novak's point about whether or not there's an ownership transfer doesn't mean that the fiduciary duties stop.
So if Astra has said, here's our 50%, and in fact is suing because they want payment for that, you're saying that the transfer of the ownership did not disavow a continuing obligation to Petrobras?
That's correct.
Okay.
That the fiduciary duties as a matter of law, as a matter of Connecticut law, with respect to the fiduciaries who were officers and directors of PRSI, one of the plaintiffs, as a matter of Delaware law, with respect to the fiduciaries and the individual defendants like Mr. Fallhaber and Mr. Wingett, those continued, notwithstanding the transfer of any ownership interest, because the law of fiduciaries is different than any law of transfer of ownership. And again, this is consistent with Texas law and Johnson versus Peckham. So why was the settlement agreement not an arm's length transaction in response to Justice Busby? Because of the fact that, one, there's evidence of a bribe being offered in connection with the settlement agreement, which my friend Mr. Novak acknowledges makes it unclear as to what that means. But even if you don't take that as being something that makes it not an arm's length transaction, as a matter of law dictated by the legislature via the internal affairs doctrine, which says that Connecticut law applies to the PRSI fiduciaries, Delaware law applies to the PRSI trading fiduciaries. As a matter of law, those fiduciary duties continue in two ways. One, notwithstanding the fact that the parties are in a dispute, okay, that doesn't absolve the fiduciaries of their duties. And even if the fiduciaries are no longer fiduciaries, this is the Pacelli case and again the Belcom case, even if the fiduciaries have somehow resigned or are no longer fiduciaries, or let's say that the ownership transfer has some impact on the fiduciaries, and we don't think it does, but even if that were true, it doesn't make a difference as a matter of law that it's not an arm's length transaction, and that those fiduciaries like Mr. Fallhaber, who was the ringleader of the bribery scheme, or Mr. Wingett, who was another individual at Astra who's alleged to receive part of those bribes and was the lead negotiator for the settlement agreement, that they had duties that continued, and those duties obligated them to tell us in connection with the settlement agreement before we signed it, the fact that there were bribes paid and that they knew about it and that they breached their fiduciary duties, which again are facts that must be taken as true for summary judgment.
Well, the fiduciary duty was running from each party's officials and employees to PRSI.
Right. I think, let me, Justice Boyd, let me look at
Prior to
it.
2009. After 2006, before 2009, each side had fiduciary duties to PRSI.
That's correct. And each had fiduciary duties to PRSI trading. Okay.
And PRSI trading. And then as of 2009, there's no longer a PRSI.
No, that's not correct. PRSI continued. It just continued without Astra having an ownership interest. But again, there's no evidence in the record. PRSI exists even as of today and existed through the time of the settlement
It's
agreement.
just wholly owned by Petrobras.
Correct. But again, that's a distinction that is different than saying that certain individuals disavowed or took affirmative steps to absolve themselves of fiduciary
Right,
duties.
but what I'm getting at, I just want to make sure, it's a little nitpicky, but I just want to make sure, is it your position that they, meaning their officials, employees, whoever, had ongoing fiduciary duties to PRSI or to Petrobras?
Well, to PRSI. I mean, PRSI is one of the plaintiffs. We represent PRSI. We represent PRSI Trading. So let me step back for a minute because this is a little confusing because we have people here who wear multiple hats. So let me look at it this way. Let's take Mr. Faulhaber. We believe Mr. Faulhaber wears at least 4 hats in connection with this settlement agreement, right? Mr. Faulhaber was an officer and director of certain Astra entities, the certain defendant entities. Mr. Faulhaber was a partner in what's known as PRHP, the Pasadena Refinery Holding Partnership, which again is an Astra-affiliated entity. Mr. Faulhaber also was a fiduciary with respect to the plaintiff, 2 plaintiffs, PRSI and PRSI Trading. He may have been only a fiduciary with respect to PRSI Trading. Mr. Wingett was a fiduciary as to both, for example.
And he was a fiduciary to those entities for what reason?
Because of the fact that he had served as a director of PRSI Trading, and because those duties, again, continue as a matter of Delaware law. PRSI Trading was a Delaware corporation, and just because the parties are in a dispute or just because there may have been an ownership transfer, it doesn't absolve Mr. Faulhaber of his fiduciary duties.
Do you agree it would end when he ceased to be a director of PRSI?
There's no evidence in the record of when he ceased to be a director of PRSI. That was the point I was trying to make to Justice Bland. Astra is trying to get you to equate the transfer of ownership interest by certain corporate entities as being the end of fiduciary duties owed by separate individuals. And what we're saying is that's legally incorrect. There's no evidence in the record, there's no case law, whatever, that they have cited to you that says when organizations transfer ownership in PRSI, which is a Connecticut corporation that still exists to this day, PRSI Trading, again, which is a partnership that continued on and was a party to the settlement agreement, they're trying to get you to equate transfer of ownership interests with end of fiduciary duties, and that's wrong both factually and legally.
Because the individuals were still board members or officers or still owed continuing fiduciary duties to the other entity.
Because there's no evidence in the record that the individuals, one, took any steps to affirmatively repudiate or remove themselves or dissolve their fiduciary duties, and second, that's a factual issue. Okay, there's no evidence in the record on that. If they want to argue that point, it would need to be this summary judgment needs to be reversed for the factual development. But our point is, even as a matter of law, if you go look at the Pacelli case, if you go look at the Belcom case from Delaware, look at Johnson versus Peckham. The fact is, even if you're a former fiduciary, okay, let's give Astra the benefit of the doubt. We disagree with it, but give them the benefit of the doubt that the transfer of the ownership interest in April of 2009 somehow stopped those individuals from serving as a director. That isn't the end of their fiduciary duties, right? Because we don't want fiduciaries, and this is what Pacelli says, and this is what Belcom says. You may be held liable as a fiduciary and have ongoing duties even if you're no longer serving as a director of a particular corporation.
That may be true. So, for example, if you had an individual who was an employee of one of the Astra entities serving as the tax partner, for example, of what used to be the joint venture, but if they're not wearing a hat like that, a specific hat, what is the source of a duty just for someone who's no longer a director or no longer functioning as a fiduciary to the other entity?
Well, I would encourage the court to take a look at the Pacelli case, for example, because what the Pacelli case says from Connecticut, it basically says that a settlement, and I quote here, this is from page 329 in the Pacelli case from the Connecticut Supreme Court. A settlement agreement and general release cannot shield an officer or director who has failed in his fiduciary duty to disclose information relevant to a transaction with those whose confidence he has abused. The fiduciary, quote, was bound to reveal his defalcations before he could be absolved by the release. And Pacelli involved a former shareholder, a former officer or director, okay? And the Connecticut Supreme Court says, listen, if you're a fiduciary, We don't want fiduciaries creating mischief. That's how this court described it in the Johnson versus Peckham case, right? We don't want fiduciaries getting in a situation like this where they pick a dispute with a beneficiary, sign a settlement agreement, all of a sudden get a release for things, but have not disclosed to their beneficiary that the fiduciary engaged in misconduct while they were serving as a fiduciary. In this situation, in the Pacelli case, it was where the fiduciary, while he was an officer or director, had basically taken corporate funds for personal use. Here, it's undisputed that these individuals were fiduciaries, even under Astra's view, from at least March of 2006, when the stock purchase and sale agreement became effective, until April of 2009, when the ownership interests were transferred. The fact is, during that entire period of time, the bribes had been paid. They had been negotiated and paid while they were fiduciaries of PRSI and PRSI Trading. At least during those 3 years, they had an affirmative obligation to tell us about material facts that we didn't know about, and that would be the bribes. And they don't get off scot-free just by transferring ownership interests and arguing that they're no longer a fiduciary after April of 2009 and get us to release claims that would cover the wrongdoing not only during the period of time when they admittedly were fiduciaries from March of 2006 until April of 2009, but even after 2009, the whole point is that those duties continue, and that's what the Belcom case.
So-
And
Just
under
to
your
be-
view, that they continue today? Under your view, they continue today?
Well, we now know about the fraud, so the duties wouldn't necessarily continue today. Once we have the beneficiary is aware of the defalcations, as the Connecticut Supreme Court says, we are now aware, because of this massive corruption scheme, that they negotiated and paid bribes, that they didn't tell us about it, that those bribes went to people like Mr. Faulhaber, who's an individual
Well,
defendant
but
here.
if you breach a fiduciary duty, that doesn't then relieve you from any obligation not to breach further fiduciary duties in the future. And I think Justice Huddle's question is, if you're right that they still had an ongoing fiduciary duty and they breached it by engaging in this conduct, under your theory, don't they still have ongoing fiduciary duties?
It would be, I would say this, I mean, once they have told us about all the material facts of which we are unaware,
Yeah,
and
but what about whatever they're conspiring to do to beat you in this lawsuit? Isn't that breaching fiduciary duty?
I don't think that that this lawsuit is a breach of fiduciary duty.
I mean, don't they, if they have ongoing fiduciary duties, why don't they have a duty to PRSI and PRSI Trading with regard to this lawsuit?
Because this lawsuit, the filing of the lawsuit itself doesn't necessarily address their obligations when they were fiduciaries and things that they knew that they should have told us about at that time.
So there's no way to settle those claims? There's no way to settle that possible liability? You can't
Not-
just sit down and say, look, I don't like you, you don't like me, we don't trust each other, let's call it quits.
No, I think you can settle it. I think the issue there, though, is that, and again, this is what the Johnson versus Peckham case says, and this is what Schlumberger talks about when the first thing it does is it looks at the party relationship. That's where you
So
start.
these are sophisticated parties.
Right. They are sophisticated parties, but that doesn't mean that there's not a asymmetry of information where these fiduciaries at Astra negotiated and paid bribes. So
But
the answer
what I'm asking is, when there's a possibility of asymmetry of information, and one party or the other doesn't know that, can they settle that or not?
they can settle that, but it's incumbent upon the fiduciary to basically disclose the material information that the beneficiary doesn't know about, so it's a fully informed settlement agreement. So can it be settled? The answer is yes. But again, Johnson anticipated this and basically said, look, if you're going to put the burden on somebody, it ought to be on the fiduciary. It should not be on the beneficiary, because otherwise it will allow these fiduciaries to create mischief, right? And so this is a situation, and again, this is what makes this case different than Schlumberger, which makes this case different than Forest Oil. We finally have a case here that addresses omissions, and we also have a case that addresses fiduciary duties. Now, they want to argue that the duties ended in April 2009. This is the first time they've disputed that. They assumed through the trial court and through the Court of Appeals that those duties were owed as a matter of law.
Even accepting everything you've said with regard to the ongoing fiduciary duties and the disclaimer of reliance, if this agreement did not include the carve-out language, would your clients be able to file this lawsuit?
Yeah, because, yes, we would, because I think you need to keep in mind the grounds on which Astra moved for summary judgment. So they relied upon, the carve-out is in the release, and then we have a separate reliance
I'm
disclaimer.
trying to move to the release
Yeah.
discussion at this point.
Well, the reliance
Let's assume you're right that they had fiduciary duties and that for some reason the disclaimer of reliance doesn't apply. Couldn't, and this kind of goes to the chief's question, isn't it possible that your clients could have said, look, it doesn't matter what the claims are, why we're entering them, nothing matters, we release everything. Give us our gazillion dollars and we'll go away. Couldn't that have happened?
That could have happened, but then if it turns out that they committed fraud, we're back to the general rule in Texas.
So the answer is no.
Well,
The reason to settle is to prevent those eventualities from resurfacing.
Well, I think the issue is with the general rule in Texas, longstanding rule, fraud vitiates everything it touches. 1997, this court set up an exception to that longstanding and well-settled rule in Schlumberger, and it's a narrow exception. So if you don't have the carve-out and you don't have the reliance disclaimer, you're back to the general rule, which is, and let's face it, I appreciate the parade of horribles that Astra has trotted out. We don't think that's the case. I appreciate the court's questions about how do you settle these things, but let's face it, Texas has been around for a long time. We've had fiduciaries in Texas for a long time. We've had releases and settlement agreements in Texas for a long time. And the fact is, if this were as big a problem as Astra says it is, we would certainly have a lot of cases where fiduciaries were unable to get themselves released or settled claims. There's not some long list of cases identifying a problem out there, right? I mean, this
Couldn't it
is
be a different rule if you basically, if the allegation is that we're accepting as true for purposes of where we are right now, that there were actually bribes paid back and forth so that there's not, it seems like a different situation than sitting down arm's length across the table and saying, I don't like you and you don't like me, so let's agree to let this go. If there's not true adversity, if you will, across the table because somebody's bribed the other person on the other side of the table, then why wouldn't, what a court say about that? Is that a different situation?
well, in that type of situation, I mean, I think there's a question of whether that's really an arm's length transaction either, right? I mean, again, we have a situation here. We haven't found a case besides this one that's like that. I mean, again, there are not a lot of cases that address fiduciary duty issues in the context of reliance disclaimers or things like that.
Chief, if I may, it sounds like, in response to my questions a couple minutes ago, that you feel like you don't need the carve-out to prevail here. But let's focus on the carve-out just for this last question. Why do your, as opposed to your fraud claims, why do your breach of fiduciary duty claims fit within the carve-out? How do these breach of fiduciary duty claims arise from the enforcement or interpretation of the settlement agreement?
Because they rendered the agreement unenforceable. I think I would encourage you, and I made a note during the court's questioning of my friend Mr. Novak, if you look at the record, pages 3814 through 3818, that's our third amended petition and includes the 3 fiduciary duty claims: breach of fiduciary duty, conspiracy to breach fiduciary duty, aiding and abetting to breach fiduciary duty. If you look at all of those claims, they all seek rescission, disgorgement, restitution, the imposition of a constructed trust. The only contract that's at issue in this case is a settlement agreement. So those claims all seek the rescission of the settlement agreement and claim that prior to the execution of the settlement agreement, the defendant fiduciaries had an affirmative obligation, had a duty to tell us, my clients, PRSI Trading, about that bribery scheme before we sign the agreement. So they do affect the enforceability of the agreement.
And if I may, Chief, just one is, in order for you to prevail on that argument, do we have to conclude that the word enforcement and the word enforceability are synonymous?
No, you don't. I mean, I think when the reason it says the enforcement and not to enforce, Astra wants to read it as to enforce, and that's not the case. The reason it says the enforcement, it applies both to claims to enforce as well as claims challenging enforcement. Because again, it's a mutual release. We didn't know who might be the party who didn't comply or had done something inappropriate. So when we have a mutual carve-outs, and Astra's release and our release have the same carve-outs, and the parties were going to be have ongoing relationships. We wanted to ensure that both parties had the ability to not only seek enforcement, but also challenge enforcement.
Any other questions? Thank you, Counsel.
Thank you.
Mr. Novak, you have 5 minutes.
Thank you, Your Honor. First, I want to clear up a fact. There is no allegation of any illegal conduct in connection with this settlement. The only evidence is an inquiry by someone to someone who wasn't involved in the settlement negotiations, which went nowhere. There is no bribe here. Second, we have taken the position that fiduciary duty breach does not give rise to a right to invalidate the settlement agreement. Whatever was alleged in the petition doesn't make it so. There is no law that says a breach of fiduciary duty committed by some individuals entitles someone who did not rely on the allegations of non-disclosure or affirmative
Right,
misrepresentation.
but a release and a carve-out relate to claims, right? So you release a claim, and then you carve out a claim from that release. And so shouldn't we focus on not whether the claim is valid on its merits, which you're arguing it's not, that you can't claim a right to unenforceability based on breach of fiduciary duty is your argument, but they may have claimed it. If they did claim it, then doesn't the release carve-out allow it?
No, the release does not carve it out. And I want to say that the releases are not identical on the carve-out. The carve-out has to be looked at in connection with each release. The Petrobras release says we release all the Petrobras claims we can bring. And the carve-out says you can bring claims to enforce this agreement. You can bring claims to have it interpreted. You can bring claims to for breach of it. You're preserving only claims by Petrobras, excluding it from the carve-out. For example, in Section 506, I believe it is, there is an obligation to indemnify Petrobras by Astra for tax liabilities that occurred during the 2006-2009 period. Literally, those would be within the scope of the release, which covers everything that ever happened, known or unknown, of any nature whatsoever. But because of the carve-out, the right to enforce that obligation is preserved. When you look at the Astra release, Astra has a right to bring a claim under the settlement agreement to enforce it. It would make no sense to declare for all the world that this is a mutual general release of all claims prior to the effective date, and then to say, by the way, anything that happens before the effective date's not released. It's not a general release. We understood Petrobras was protecting itself. We were protecting ourselves. Now, with regard to fiduciary relationship.
If Astra filed a suit to enforce this settlement agreement.
Right.
And Petrobras, in response to that suit, general denial plus counterclaim saying breach of fiduciary duty and fraud prevent you from enforcing the settlement agreement, would those counterclaims fit within the carve-out?
The fraud claim is not within the carve-out because it invalidates the entire agreement.
So it goes to the...
It goes to the disclaimer.
Enforcement.
It has to be a claim by Petrobras. The carve-out preserves for Petrobras the right to sue affirmatively to enforce its rights.
Well, but that's not exactly what it says. It says the claim can be connected in any way with the enforcement of the agreement.
Yes, but it's got to be a claim.
Why isn't a claim that it can't be enforced connected
Well,
in some way with the enforcement of the agreement?
If you interpret it any time that Petrobras challenges the enforcement of the agreement, then the carve-out swallows up the entire release. Because any time that Petrobras brings a claim for X, Y, or Z, we invoke the release. They say the agreement is no good, and in any event, there's a carve-out. Because anything that relates to a claim that this release doesn't apply is covered by the carve-out. It makes no sense to say that. What it does make sense to say is if there are claims that arise under this agreement, they're not released. That's the purpose of this. Why would you call it a general release? If I might jump to this issue of this Pacelli case, the cases outside of Texas. In those cases, we're not quarreling whether there was a lingering fiduciary duty. Petrobras has never alleged that anyone continued as an officer or director after we gave up all of our ownership. They haven't made that allegation because they know it would be untrue. But we're assuming for purposes of argument, there was a lingering fiduciary duty to disclose at some point in the future, from after we cease to be partners, something. That fiduciary duty claim is covered by the release. The release, if the settlement agreement is valid, if it was not obtained by fraud, then the release covers the fiduciary duty claim. And in the cases involving Connecticut and Delaware, there was not a disclaimer issue. The foundation of this claim on our part is the Schlumberger doctrine. Schlumberger doctrine did not exist in those cases. All those cases stand for is you may have a lingering fiduciary duty when you're no longer actively serving as a fiduciary, but they never dealt with the issue, which is governed by Texas law, under a Texas agreement, by Texas parties, under the Schlumberger doctrine. What they are proposing is fiduciaries can never settle unless the fiduciary discloses what he fails to disclose, which forms the basis of the lawsuit. There are 3 or 4 cases in the Court of Appeals which have dealt with this. They have all rejected the notion that fiduciaries per se cannot settle. What the Schlumberger doctrine does with the multiple factors is they look at all of the circumstances of the settlement. They look at whether they were arm's length, sophisticated counsel. Here, as Justice Bland pointed out, Petrobras put in the language you quoted. It was in their version of the original release. No matter what has happened in the past, we are done. There's never been any testimony. There's never been any evidence. There's nothing to indicate that the parties did not want to have a complete, clean break. So,
Any other questions? Thank you, Mr. Novak. The case is submitted. That concludes the argument set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.